5 p.m. I want to welcome the members of the Senate Rules Committee. I want to give a special welcome to our Vice Chair, Madam Vice Chair, Senator Fuller. Welcome. To the guests that we have here today, we have two appointments before us. That is Charles Chuck Supple and Mr. Joseph Liu. Before we go to our government appointees, why don't we establish a quorum? Madam Secretary, please call the roll.
Senators Canella?
Here.
Canella here. Leyva? Here. Leyva here. Mitchell? Here. Mitchell here. Fuller? Here. Fuller here. DeLeon?
Here.
DeLeon.
Okay, we've established a quorum. Let's go to file item number 1. File item number 1, which is the reference of bills to the policy committees. We have a motion made by Ms. Mitchell. Madam Secretary, please call the roll.
Senators Canella?
Aye.
Canella aye. Leyva? Aye. Leyva aye. Mitchell? Aye. Mitchell aye. Fuller? Aye. Fuller aye. DeLeon?
Aye.
DeLeon aye.
File item number 1 passes on a 5-0 vote. Let's go to file item number 2. That is Charles Chuck Supple, who is a commissioner for the Board of Parolee or Board of Parole Hearings. Mr. Supple, welcome.
Thank you very much.
If there's anyone you want to introduce, friends, loved ones, please do so and give us a short statement.
Sure, thank you very much. I'm joined today by my partner, Daniel Zingali, who is in the audience.
I did not know he was your partner. Welcome, Daniel.
My extended family from the Division of Juvenile Justice, Director Minor, and from CDCR, Ms. Rosales. And I see Scott Budnick sitting over there as well. So
Scott Budnick, you already were confirmed about a month ago. Unless you're coming back. I don't know if Ms. Mitchell recalled you back or someone else, you know. Yeah.
It's risky to come back.
It's risky to come back. They want a second bite at the apple. You're forewarned.
But Senators of the Rule Committee and President Pro Tem, Mr. De Leon, I want to thank you for the opportunity for being considered to be able to continue in my role on the Juvenile Parole Board. As meeting individually with you in the materials that were provided to you, you see this is my second time at bat, so to speak, on the Juvenile Parole Board. That's coming off of serving nearly 5 years as a parole agent in the Division of Juvenile Justice. Prior to that, I served nearly 8 years on the Juvenile Parole Board as a commissioner as well as the executive officer. And my time in the field, so to speak, over the course of the nearly past 5 years as a parole agent, supervising youth coming out of DJJ in the greater Sacramento region, and then serving as a reentry coordinator for about 4 years in the OH Close Youth Correctional Facility, I think puts me into a unique position and a strengthened position and experience and perspective to be able to continue the work of the Division of Juvenile Justice's Juvenile Parole Board in our efforts to try to align the decision-making process with all of the reforms that have been implemented in the division over the past few years. And I'll leave it at that and provide you with more information as you ask questions.
Thank you very much, Mr. Supple. So why don't we open up to questions, commentaries from the members. We'll start with Ms. Leyva.
Thank you, Mr. Pro Tem. Good afternoon, Mr. Supple.
Good afternoon.
Very good to see you again. I will say, as I said when we met, how much I enjoyed meeting with you. You have a wealth of background. I think that you're very well suited for this, and we are very lucky to have you. One question I didn't ask when we met, is there anything in particular you look for in a juvenile, any programs that they may or may not have completed before you would assess them to be paroled?
Well, the first thing that I'd look for, thank you for the kind comments as well. The first thing I would look for is, what did they come here for in the first place? In the vernacular, what are their risk factors to reoffend? I mean, that's what we should pay the most attention to, because that is what puts them at the greatest risk for going out and doing harm. And there are assessment instruments now in DJJ, the Youth Assessment Screening Instrument, that helps us be able to hone in on what those risk factors are. It could be anger and aggression. It could be social cognitive, criminal thinking. It could be peer influences. But each youth is different and unique. And the art of it, or science, so to speak, is to really hone in on what are those and did they receive the treatment to be able to address those specific risk factors. And then from that, taking a look at and trying to find evidence of, has there been a fundamental change in the attitudes, in the beliefs, in their thinking, and ultimately their behaviors that were associated with what brought them there in the first place.
Perfect. Thank you very much.
Thank you very much. Senator Mitchell.
Thank you, Mr. Pro Tem. So at any point that you're interested in job sharing, just call me. And I think that, the work that you're doing is very important. Talk to me, educate me and my colleagues a little bit about really the difference between the adult versus juvenile process. I think we probably spend more time, certainly in the context of Rules Committee, confirming more of your colleagues that serve the adult side of the parole board. But it's very different based on our conversation. So talk to me about the difference from your perspective. What should we understand fundamentally based on legislation we voted on, based on the current structure of the adult versus juvenile system? So how is it different from the lane you live in terms of making those assessments from the adult side that we probably spend more time in Rules Committee confirming commissioners and discussing?
Sure. I think one of the fundamental differences between the adult side and the juvenile side as it relates to the release decision-making process is on the adult side, it's a matter of largely if the individual is going to get out. On the juvenile side, it's a matter completely of when will the individual get out. They all the youth who are adjudicated to DJJ will be released at the age of 23. Actually, it's 3 to 4 months prior to turning the age of 23, given a relatively recent change in legislation to give the youth, irregardless of how they've done in DJJ, an opportunity to be able to be supervised by county probation. So really what we're, making a decision about is, not will this young person, ever see the light of day or get back out onto the streets. It's a matter of when is it safe to be able to release them. And then the basis of that decision really wholly rests on, the treatment, a fundamental.
What we have done to prepare them.
Exactly. I think a fundamental difference, and I don't mean to throw CDCR adult under the bus. It's moving more in a direction of rehabilitation as well, but we are solely about rehabilitation. That is our charge. That's the reason the youth were adjudicated to DJJ. So in terms of fulfilling our responsibility with regard to the mission of treatment, as well as being able to protect the public, we have got to do everything we can during the time that we have them to give them every opportunity to change using the tools that are known by science as having the greatest possible chance of being able to help them change. So what we're taking a look at is where are they at in terms of their stage of change? How well have they taken to the treatment, so to speak? And again, how have their thoughts, beliefs, and attitudes changed? How is that reflected in a change of behavior? Those who have taken to it well, those who have been able to change and reduce their risk significantly, the next step is for them to go out under county probation supervision for reentry in the community. Those who have not need to stay longer, and hopefully for a greater opportunity to be able to benefit from the treatment and to see some change at some point prior to 3 to 4 months before turning 23.
I understand that the vacancies in the board composition is intentional. It's not just that the governor hasn't taken action, that you are the appointee with the support of a couple of civil service staff supporting you. Based on the workload, are you enough?
Based on the workload, I am enough. There have been, I was going to make a glib comment, or there's never enough, but it is a division that has undergone tremendous change, and that's been in part due to a lot of factors. Legislative action, governor's action, administrative action, as well as judicial action. And it's been a number of years in the making. It has gone from, in the late 90s, a population of 10,000 to approximately 700 right now.
And that number will continue to shrink, or do you think that we're at kind of the new normal?
I personally think that, I can't speak with regard to a full familiarity with the numbers and the trends and what have you. I think that what the vision has been sort of honed down to is developing an expertise to be able to address the challenges of youth that the counties have tried and have not been able to successfully treat, and that there's a role for the state to be able to provide the next level and the best possible treatment to be able to help these tremendously challenged and dangerous youth. and we had our own version of AB 109, Senate Bill 18 a while back, or 81, that actually the less serious and violent offenders, and that's by code, the non-707Bs, counties could no longer send to DJJ. And that practically halved the population and also closed a number of institutions. And so the overall population, plus the fact that there's been a decrease in juvenile crime, has really, made the overall population, much diminished. And so one appointed commissioner at this time, as well as having the two board representatives of what they are called, are able to handle the workload.
You've had a unique experience in that you've served on a, former version of the Juvenile Parole Board. You were then appointed as executive officer, and now you're back under kind of this new paradigm. And you've now served in this capacity since last fall. With your impending new appointment, if you will, or the extension of your appointment, what do you hope to, what's your new goal in terms of your board service? What's your goal in terms of what you hope to accomplish this time around, given your experience, given all of what you bring to the appointment?
I think that in part to finish a piece of work that I was working on in my previous position as the executive officer. At that time, the Farrell lawsuit, the remedial plans were largely in the planning and very early stages of implementation. And a critical piece of work that needed to be accomplished was realigning the decision-making process with all the reforms that were taking place. I mean, it makes sense. If you're going to have all of these changes taking place, the way in which you make those decisions needs to reflect those changes. And now is the time. We are at a point where that work needs to be completed. At this point, many, if not practically all of the reforms have been implemented. And the way then the board makes decisions with regard to readiness to release need to reflect the assessment instruments, need to reflect the treatment programs, need to reflect the case planning process within the system in order to be able to arrive at the right decision. So a large part of why I wanted to come back and what I hope to achieve is to be able to assist the division in revising and realigning aligning the decision-making process, plus to be able to do whatever good I can with regard to encouraging, motivating, supporting the youth in the system, give them a fair shot at release, as well as making sure to have those youth that are in need of additional treatment to be able to stay and benefit from that.
Thank you very much.
Sure, thank you.
Thank you very much, Ms. Mitchell. Mr. Cannella.
Thank you, Mr. Pro Tem. So we didn't have a chance to meet, but we've looked at your background. You're obviously very qualified for the job, and I've learned more about parole, hearings and how they progress. We recently had, I think, 7 of the adult parole officers here. So what's the difference if they shall be released by 23? So what do? You start looking at them at every year? I mean, 700. That's a lot. I mean, how often do you engage with these young folks to see if they're eligible to be released?
When a youth comes in, and these are youth who were adjudicated to DJJ, so they are the ones who come to DJJ and we have jurisdiction over. We also house the juveniles who are committed as adults, okay? And we do not conduct hearings for them. We do not have jurisdiction over them. They fall under the adult parole system, if indeed their term was such that they need to go before the adult parole board. So we see youth who are adjudicated to DJJ. When they first come in, they're assigned a category based on the nature of their crime. So the most serious ones, fall under like a category 1, a category 2. That could be murder, it could be rape, it could be carjacking, all the way down to, let's say, a category 5, which are, perhaps an assault or a similar type of crime. Serious, but not as violent as the higher category crimes. And each category has a date assigned to it, a number of months or years, in which they're guaranteed a chance to come before the board to be considered for discharge. So for instance, somebody who comes in with a PC 187 for murder, they are assigned their first board hearing 7 years from the date that they are accepted into DJJ. Now they're eligible for time cuts to reduce that, based on their successful programming and treatment. And then that goes all the way down to Category 5. Their initial parole board date, discharge consideration date, is set at 18 months. So basically, that sets the clock in terms of how often we would see see an individual. And so, for instance, if they come up for discharge the first time and they are denied, then by law, they are given an extension of no more than 6 months, which they would see us again. And we would continue to see them until, they are ready for discharge if they had not already been discharged.
So if they're 17, would they go to the adult prison then? I mean, because they'd be over 23 in 7 years.
No, if they were adjudicated as a juvenile, their jurisdiction ends at the age of 23, irregardless. Now,
So
had they
does that
been,
mean they're released, or would they go to I'm going to call it adult prison? I guess I can't think of the term, but would they go to prison still, or would they just be released out on the streets?
well, it would have to be 3 to 4 months prior to their end of the jurisdiction, so they would go under county probation.
Okay, so not locked up anymore, so in county probation.
Correct. Yeah, the district attorney made a decision during the handling of the case.
Okay,
that
they
if
could have tried him as an adult.
Exactly.
process. Okay, so because they went that route, that's why they're eligible.
Exactly.
How are we doing, I mean, if the goal is to, I think the goal of prison is to rehabilitate ultimately. I mean, there's some folks that need to stay in there forever, but a lot of them we want to rehabilitate and get them out and be productive. How are we doing, and this isn't really your jurisdiction, but you see these kids all the time, how are we doing with rehabilitating the kids?
I think from my perspective, in terms of the youth that come before us, and in terms of talking about the, realigning the decision-making process and what we're holding the youth accountable for, you'd be surprised how articulate they are with regard to what their risks were that they walked in here for. They're not saying, I'm here because, I'm a bad boy or something like that. They're able to talk about, I have a problem with anger and aggression, or I have a problem the way that I think. And they're able to talk very specifically about what those thoughts are, what those beliefs are, and then to be able to share, what they have learned from the program. And the programs, in part because of the force of the law and the court orders and the like, are really some of the best in the country with regard to having the greatest possible chance of trying to reduce those risks. So they are given tools to be able to, think before they act, to be able to recognize when, their risk factor of violence and aggression is on the rise, and to be able to try to intervene in that process. And they're able to talk about it, so the conversations that we're having with them, their ability to be able to grasp the materials and the like, is promising. Particularly since my last, round, that they are able to grasp the treatment. They're able to have an understanding of much more of the specifics of what they are there for and the underlying, causes of that, and to be able to demonstrate, some it takes longer than others, an ability to be able to apply, these tools in instances where otherwise they would have been, bad actors.
So since they come to you and you make the decision on whether they can be released early, do you have much interaction with DJJ and say, look, you guys need to do a better in this area, or this is what I'm looking for. I see the kids I'm seeing are deficient in these areas. I mean, how interactive is the relationship?
It's very interactive. Treatment team representatives are each one of the hearings. We participate in all of the training that has been taking place with the integrated behavior treatment model, which is, basically all of the treatment programs and the casework and the like. So we're quite knowledgeable. We know the level at which the staff are to perform and what that they should be providing to the youth. And we have this unique vantage point, this unique perspective where we can see, basically how the provision of treatment has been. One, was it actually assigned correctly in terms of the risk factors? Two, did the youth participate in it? And, are the youth actually getting something out of it? Although it's not an official part of our duty, because our duty is specifically doing the release decision, hearings, we do participate in the initial case conference where a youth has been there and assessed, and the initial case plan is put together. It happens about 30, 60 days out, and to be able to introduce ourselves to the youth and communicate to them the expectations with regard to release, as well as to be able to review what the plan is for this youth. Are they going to have the treatment assigned that they need? And we participate in annuals periodically, where it's the treatment team and the facility doing the annual review, but we're participating in it as well as another set of eyes to make sure that the youth is being provided the treatment as well as that the youth is taking to it.
Great. All right. Thank you very much.
Thank you.
Thank you very much, Senator Cannella. Madam Vice Chair.
Well, we had a really good visit in the office, and I appreciate your being willing to instruct me as well as give me your experience, the benefit of your experience. One of the things we talked about that I found quite interesting was that we found that there's been a couple new laws passed, particularly SB 260, I think, and some others that changed the formula for how you determine when adults are and juvenile offenders are given their first hearing. And I'd like to go over again. So what reports on recidivism are available to help the legislature and the public assess the impact of those students or those parolees that are now getting out under maybe a shorter sentence than they would have had prior, based on the new formula?
I would not be able to speak to reports associated with the adult commits that are coming out under the new formula. That doesn't fall within the purview of the Juvenile Parole Board, so I'm not knowledgeable of the literature with regards to the results of that particular piece of legislation.
Is there something that helps us assess just the juvenile population that is being paroled?
It will be forthcoming. The Division of Juvenile Justice has just been accepted as part of a program of the Pew Center, and we're one of, I think, of 5 states that have been selected to be part of a seminal juvenile recidivism study. And so it's timely in that we're going to, at a time where we're far enough along in the reforms that we should be able to, hopefully that it has had an impact in terms of their success or not in the community, that particular study is going to be timely to see indeed if we're having any results. And I know the director also of DJJ has recently met with CDCR research staff to begin to design some of our own recidivism studies to be able to get a handle at just how well we're doing.
Will those be available to the public, or will they be on the website, or how can we access some of the accountability reforms that you're?
I would assume they'd be available. I know that certainly Pew would be championing the research and want to share that, and certainly you're a critical audience.
Great. And so, given the lack of that, what factors do you use to determine when a youth has been sufficiently rehabilitated and returned to the community?
Well, I think the bottom line is, and as I kind of alluded to this before, first determining exactly what are they here for? What is their risk factor? And there are certain risk factors we know correlate very highly to risk to reoffend. Anger and aggression, needs to be treated in a secure environment. Social cognitive is another risk factor. It's their thinking, oftentimes referred to as criminal thinking, needs to be addressed in a secure environment. Peer influences, when that gang involvement is related to that, as well as attitude. 2 other very critical risk factors that need to be addressed within a secure environment. There are others, substance abuse. There's protective factors, which also are critical. Those are the things that, will basically help to protect a youth from those risk factors, and if you're able to lower the risk factors, to be able to keep them down. So first thing, we're looking at the risk factors related to risk to reoffend that they came in with. Second thing we're looking at, does DJJ have the treatment to be able to address those risk factors? The best possible treatment, proven by science, is to be, having a chance of being able to reduce those. Did the youth participate in that treatment? Then we get to, what has been the result of participation in that treatment? Did they complete it? And has there been a change in the thoughts and the attitudes of belief connected with those risk factors? And are we seeing a change in behavior as well? And that's really what we're keeping our eyes on and trying to draw a bead on in terms of, are they ready to be released? They should be able to talk about the treatment. They should be able to demonstrate the utilization of the skills gained from the treatment, and they should be able to talk about have demonstrated a change in behavior. But then what we're also looking at is pursuit towards a positive life plan. It's not enough that they're going to go out there and do no harm. What we're looking for is, are they going to lead a successful and productive life? That's a good thing, but it also is what will help keep those risk factors reduced. So when they came in, what was their plan with regard to education, employment skills, relationship with family, other adults in the community, and identification of resources in the communities that will be there for when they leave, and how have they progressed in developing that plan? Every youth that leaves has an integrated reentry plan that basically spells out what are your next steps for education? What are your next steps for employment? What are your next steps with regard to other resources in the community? And specifics, not just general, but specifics, names, addresses, phone numbers. And we would weigh that as well in terms of looking at the reduction of risk.
So a juvenile that comes to you and they have a adjudication already taking place. So let's say they get out at 23, since everyone does, and they indicate to you in their final hearing that they're still concerned about maybe gang entanglements when they get out on the outside, or substance abuse or something that's beyond your reach within the incarcerated period. Are there resources that you give them or point to, or that when they're on the outside they can go to shelter themselves from being reemployed by a gang or getting back into, I guess the substance abuses may be easier, but still, is there a pathway delineated, or are they just sort of dropped at the gate of probation?
Yeah, every youth, irregardless of, when they are released, we're calling it max, they refer to it as maxing out. So, a youth who basically had not programmed, had not done well the entire time that they were there, and maxed out and is mandated release 3 to 4 months prior to turning 23. Every youth has an integrated reentry plan, and particularly those youth who have reached this stage, the plan's going to be loaded up in terms of, you have some ongoing risks here that need to be addressed in the community. And as you mentioned, substance abuse, and anything else we can find in partnership with probation that could be of benefit to them, that, at least they'll have it as a part of their, their exit plan. Hopefully that they would, continue to pursue that. But we're doing it in partnership with most of, the more active counties, probation departments who are able, and, who intend to be able to supervise and to be able to see that these youth get linked to these resources.
And then what are the ways that a youth could move up the date of the first discharge consideration hearing?
They're available for time cuts. So by participation in treatment, as well as, in terms of advancing toward these other life goals that I was talking about with regard to, education and employment and the like, they are eligible for time cuts based on their level of incentive, their level of performance. And what the DJ is going through right now as part of the reform is revising the whole behavior management system and the whole program incentive system so that those time cuts are much more connected to their actual progress in treatment and training. So in other words, it's not a matter of, oh, you get a time cut because you picked up a piece of paper, on the unit hall or something like that. It has to do with their progress in treatment, reducing those specific risk factors.
Right. Do you find that in those cases that have moved up hearings that the juveniles are more likely to be released?
Not necessarily. In the future, possibly, as the incentives are tied much more closely to their actual, risk factors and the like. So I wouldn't say necessarily.
Okay, thank you. And
Thank you.
you for all your answers today.
Thank you. Thanks for the opportunity.
Thank you very much, Madam Vice Chair. Mr. Supple, I'm going to make it very simple for you. You had me at Daniel Zingali. So,
I tried. I'm sorry.
kidding aside, I think it was very robust dialogue and conversation. I reviewed your file. Very impressive. Obviously, your history, what was then CYA, where you're at today, being a former parole agent, now commissioner, listening to the questions and answers. And the back and forth convinces me, obviously, that you're more than suited for this position with your temperament, with your outlook, with a sort of a holistic outlook with regards to these young men who are obviously troubled for a whole variety of reasons, poverty factors, and women. And I am happy to entertain your confirmation today. So why don't we get to those who are in support of today's nominee. Those in support, come on up. Seeing none right now. Those in opposition? Anyone in opposition? Seeing anyone who's agnostic about Mr. Supple? Yeah. Seeing no one, can I entertain a motion? We have a motion made by Ms. Mitchell. Madam Secretary, please call the roll.
Senators Canella? Aye. Canella, aye. Leyva? Aye. Leyva, aye. Mitchell? Aye. Mitchell, aye. Fuller? Aye. Fuller, aye. DeLeon?
Aye.
DeLeon, aye.
Mr. Supple, your confirmation from the Rules Committee passes on a 5-0 vote. Congratulations.
Thank you very much. Thank you.